Imagine this. You have just brought a life into this world. You are exhausted, emotional, and still healing. And then your employer hands you a letter telling you that your maternity leave has been denied. Not because the law doesn't protect you, but because someone decided to interpret the law in a way that keeps you out. This is not a fiction, this has happened. To the teachers, to the doctors, to nurses, to daily wage workers, to women across India who had fought a legal battle at the most vulnerable moment of their lives. But here's what is extraordinary. When they went to court, India's Supreme Court stood up for them. Today we are going to walk through these battles, judgment by judgment, story by story, and at the end we are going to look at what the world's most progressive countries are doing. So you can judge for yourself where India stands and where it needs to go. Before we get to the judgments, let's understand the foundation. India enacted the Maternity Benefit Act in 1961 as one of the earliest labor protection laws for women in the post-independence era. Its sole purpose was simple and humane. A working woman should not be punished for becoming a mother. Originally, it provided 12 weeks of paid maternity leave. Then in 2017, a landmark amendment changed everything. A maternity leave was extended to 26 weeks. For the first time, it was even introduced to the surrogate mothers and also the adoptive mothers. But here's the cruel gap between law and reality. Having a law on paper is one thing. Getting it actually enforced when the employers resist, when bureaucrats sign their technicalities, when the states impose conditions the law never intended, it is completely different battle. That is where the courts stepped in. And that is where our story truly begins. There are so many recent judgments. Hamsa Nandini Nanduri versus Union of India in 2026, Justice Pardiwala and Justice Mahadevan had delivered this wonderful judgment. A woman legally adopts a child, she applies for a maternity leave, and then the government says, sorry, your child is older than 3 months, so you don't qualify. Think about that for a moment. By the time the legal adoption process is complete in India, the paperwork, the court orders, the CARA regulations, the child is almost never under 3 months of age. The law was giving a right with one hand and it was taking it away with the other. The Supreme Court called this out with devastating clarity. It declared that the 3 months age restriction under section 60 subsection 4 of the Social Security Code of 2020 was unconstitutional, as it is a gross violation of Article 14, that is right to equality, Article 21, that is right to life and dignity. The court stated that the object of maternity benefit is not the process of childbirth, but the process of motherhood. Adoptive mothers are mothers. They are entitled to 12 weeks of paid leave, regardless of the child's age at the time of adoption. And in a powerful aside, the court urged the union government to introduce a formal national framework for paternity leave as well, saying caregiving must be a shared responsibility. This judgment didn't just change a law, it changed the definition of motherhood under Indian law. In K. Umadevi versus Government of Tamil Nadu of 2025, the judges, Justice Sanjay Kumar and Justice Ehsanuddin Amanullah, they gave a wonderful judgment. They said that here is a story that will break your heart and then restore your faith. A woman marries, has 2 children. Her marriage falls apart. She divorces. Her children goes to live with her father. She rebuilds her life, gets a government job, as a school teacher in Tamil Nadu, she remarries and becomes a pregnant mother. For the first time in her new marriage and for the first time as an employee of the state, the Tamil Nadu government denied her maternity leave. Their reason? She already has 2 children. She violated the state's 2-child norm policy. The Madras High Court's division bench agreed with the government. They ruled that the maternity leave is a statutory right, not a fundamental right, and the state's population control policy takes precedence. She appealed to the Supreme Court, and the Supreme Court said absolutely not. The court declared that the maternity leave is integral to maternity benefits, which are part of the reproductive rights and are protected under Article 21 of the Constitution. The 2 children of her first marriage were born before she entered service, and living with their father cannot be counted against her. The Supreme Court, while delivering this present judgment, referred to the landmark judgment of Suchita Srivastav versus Chandigarh administration. It is a 2009 judgment. The court reaffirmed that a woman's right to make reproductive choices is part of her dignity, her liberty, and her constitutional parenthood. The state's 2-child norm policy was not illegal, but it could not override a woman's fundamental right. The teacher got her maternity leave, and India got a precedent that maternity leave is not a concession, it is a constitutional guarantee. The next case is all about Dr. Kavita Yadav versus Secretary, Ministry of Health and Family Welfare. It's a 2023 judgment. A woman doctor working on a contract in a Delhi government hospital, she becomes pregnant near the end of the contract. She applies for her 26-week maternity benefit under the law. Her employer gives her just 11 days of leave. That means the days remaining in her contract, and then cuts her off. The Central Administrative Tribunal agreed. The Delhi High Court agreed. The 2 courts said your contract is over, so your rights are over. The Supreme Court disagreed. The court held that maternity benefits are not just coterminous with the contractual tenure. Once a woman has worked for the minimum required period of 80 days, she has earned the statutory right to full maternity benefits under Section 5 of the Maternity Benefit Act. And that right does not evaporate when the contract expires. The court also clarified that under Section 12, subsection 2A of the Act, stopping maternity benefits because a contract ends constitutes discharge, which is legally prohibited. The Act's Section 27 also gives it an overriding effect over any contract or rule inconsistent with it. No contract can strip a woman of this protection. The message was very clear. Employers cannot hide behind contractual technicalities to deny a woman her most fundamental workplace protections. This judgment extended a shield of protection to thousands of women in temporary, contractual, and casual employment across India. The next judgment is Municipal Corporation of Delhi versus Female Workers Association. It was also known as the muster roll judgment. Foundational maternity benefit judgments in Indian legal history. Daily wage worker women employed by the Municipal Corporation of Delhi. The women who swept streets, carried bricks, did the hardest physical labor of the city. She was denied maternity benefits because they were classified as temporary workers. They had no permanent status, so they could not go for any maternity leave, this was said. But the Supreme Court drew upon Universal Declaration of Human Rights, the directive principles under Article 39, 42 and 43 and Article 14 and 15 of the Constitution to deliver a resounding judgment. The nature of employment cannot determine whether a woman should get her benefits. The Maternity Benefit Act applies to daily wage workers as well. It applies to the casual workers. It applies to every working woman who qualifies under its provisions. The judgment planted a seed. Every subsequent maternity case, including Kavita Yadav, 2 decades later, grew from this root. On the other hand, we are having the case of Neera Mathur versus Life Insurance Corporation of India. It's a case of 1992 where a woman applies for a job at LIC. As part of the recruitment form, she is required to disclose the dates of her menstrual cycles, any previous pregnancies, and other deeply intimate medical details. The Supreme Court condemned this practice, calling it embarrassing, humiliating, and a violation of a woman's modesty and self-respect. It directed LIC to delete such requirements from its forms. The court also warned that using pregnancy status to avoid hiring a woman would be open to constitutional challenge. This was not merely a maternity case. This was a case about dignity at the hiring stage. And it established that a woman's reproductive life is her own, not a bargaining chip for her employers. The next case is all about Air India versus Nargesh Mirza. This is a case of 1981. You must have heard about this judgment for sure. It was that Air India had a service regulation that was almost medieval in its logic. An air hostess would lose her job upon her first pregnancy. Women who flew at 30,000 feet, served thousands of passengers, and were held to impossibly high professional standards were told that becoming a mother meant the end of their career. The Supreme Court struck down this regulation as arbitrary and violative of Article 14. The employment rules, the court declared, cannot punish a woman for their biology. A woman's role as a mother cannot be weaponized to end her career. This judgment was ahead of its time. In 1981, when workplace gender equality was barely discussed in Indian policy circles, the Supreme Court drew a line from it. Now let's zoom out. Let's look at what's happening beyond India's borders, because comparison is the best teacher. In Sweden, perhaps the world's gold standard, the parents receive 480 days, that is over 16 months of shared parental leave paid at approximately 80% of their salary. Each parent has 90 days that they must take personally. This is to encourage the fathers also to participate equally. The government also offers a gender equality bonus to the households that share the leave evenly. Sweden introduced paid maternity leave back in 1955 and has never looked back after that. Iceland. Here is another equality model. As of 2021, Iceland gives each parent 6 months of leave paid at 80% of their salary. That means that the parents would receive 80% of their salary while taking care of the baby. Parents can transfer up to 1 month to each other, and remarkably, it has been seen that the fathers in Iceland use approximately 45% of their total parental leave benefits, because the system was designed to make it normal, even expected for the fathers to be present as well. In Finland, since 2021, all parents, regardless of their gender, receive 160 days of parental leave each. Single parents receive the full entitlement of both parents combined. The first 16 days are paid at 90% and the remainder at 70% of income. Canada offers up to 18 months of combined maternity and parental leave with standard benefits covering approximately 55% of earnings. Critically, Canada allows parents to extend the leave period by choosing a lower weekly payment, giving families the flexibility. And now, And now comes the US, the only high income country in the world with no mandated national paid maternity leave. The workers get 12 weeks of unpaid leave under the Family and Medical Leave Act only if they have worked long enough at a large enough employer. So whether you get paid depends entirely on your state, your employer, and your good luck. So for the wealthiest nation on earth, this is a staggering absence of policy for sure. But amidst everything, where does India fit in all this? India's 26 weeks for the first two children actually places it respectively on the global scale. But the gap is not in the law, it is in the enforcement, the awareness, and the coverage of informal workers who make up the vast majority of India's female workforce. So what do all these court battles, these women, these judgments tell us? They tell us that rights don't enforce themselves. They tell us that a law written in the parliament and the right enjoyed at a workplace are two very different things. And the distance between them is often measured in courage. The courage of a teacher in Tamil Nadu who refused to accept that her children from a previous marriage defined her future. The courage of a contract doctor in Delhi who said, I earned this and I deserve it. The courage of a daily worker who asked, why does the nature of my employment decide whether I deserve care? These women, most of whose names you will never know, walked into the courtrooms and changed the law for every woman who comes after them. Here's what you need to know if you are a working woman in India. Maternity leave is not a favor given to you by your employer. It is your constitutional right. It is a fundamental right protected under Article 21, the right to life and dignity. It cannot be denied because of your employment type, your number of children from a previous relationship, the expiry of your contract, or your employer's reluctance to comply. And if it is denied, the courts of India have proven time and again that they will stand with you. If this video helped you understand your rights, share it with everyone, including every working woman you know, because knowledge is the first courtroom, and in that courtroom, everyone deserves to win. Thank you all. Thank you very much.